Good afternoon, everyone, and welcome. My name is Cathy Hoar. I'm a solicitor and a professional support lawyer at Lexis Plus UK Employment. I'm joined today by Stephen Ratcliffe, who you may know. He's a partner in the Employment and Compensation team at Baker McKenzie. Stephen advises on a full range of contentious and non-contentious employment law matters, for which he has been ranked for multiple years in Chambers and Partners. He is a member of the Legislative and Policy Committee of the ELA, and he is a member of our consulting editorial board here at LexisNexis. He has particular experience in the more technical aspects of domestic and multi-jurisdictional employment matters, including misclassification and related employment tax issues, holiday pay and equal pay, including designing and conducting equal pay audits. You're looking slightly surprised, Stephen. But
It's absolutely true. I didn't make that stuff up on the website, trust me.
So welcome and thank you for joining me today.
Thank you.
So we are here to talk about the Employment Rights Bill that was published on the 10th of October of this year, 2024. It's a fairly chunky piece of legislation, 158 pages long. I think it's got 119 clauses and 7 schedules to it. It's got a number of really quite significant changes for employers and their advisors to get to grips with. So rather than trying to deal with all of those and overwhelm everybody, we are going to just focus on 5 today. Changes to unfair dismissal and probationary periods, right to guaranteed hours, changes to the Equality Act related to harassment, changes in the way that labour market legislation is going to be enforced, and protection against fire and rehire. This should leave time for some questions, so if you have any as we go along, please put them in the Q&A button, which I think should appear on the right hand of your screen. So before we make a start, Stephen, I thought it might be worth just kind of setting the scene a bit in terms of timetable. We're not looking at something that's imminent. We've got quite a lot of time probably to get to grips with what's about to happen. We've got 4 consultations already launched in October. We've got a number of consultations likely to come in 2025. Much of legislation needs secondary legislation regulations to support it. And the government has said that in most cases, the legislation isn't going to come into force until 2026. And it said that in particular in relation to unfair dismissal.
Yeah.
So, I mean, that's a good thing for employers in the sense that there's time to get to grips with the changes, but also to take a look at the consultations and see if they want to submit a response themselves, what it means for them. Exactly,
yeah. This is draft legislation only, so in principle there is the opportunity for changes to be made. The government's been pretty clear in terms of where it wants to go policy-wise. It was clear from kind of the manifesto onwards. The Make Work Pay paper that was published at the same time as the bill, again, is pretty clear on what it's seeking to achieve. Nonetheless, there is, I think, through consultation, the opportunity to influence how it's done, to point out some of the sort of unintended consequences, of which there are probably a few from some of this. So with my Employment Law Association hat on, we're certainly contributing to the responses to consultation, and as you say, some have been published. There'll be some more that follow probably early next year. So employers certainly should take a look at those and feed in either directly or through their federations if they feel the need.
Yeah, thank you. So let's start with unfair dismissal. Just to briefly set out where we are now, the qualifying period for unfair dismissal has yo-yoed a bit over a number of years. It was 2 years, it went 1 year in June 1999, it's increased back to 2 years in April 2012. So generally, an employee can only bring an unfair dismissal claim if they have that qualifying period, but unless the reason for dismissal is one of the automatically unfair reasons when it's generally disapplied. So rather than changing, one option open to the government was to change the qualifying period or to say it was 0. That's not what they've done. They've repealed the relevant section. But it's still not quite, I suppose it's still not quite the day one right that they were promising, because we've got this thing about probationary periods or initial period of employment. So the test is modified if within the initial period of employment, the employee is dismissed for one of a number of reasons. And those are generally the potentially fair reasons, apart from redundancy, which is carved out.
Yeah, so, it's interesting that, isn't it? They sort of flip-flopped a little bit. I think it was May last year when there was a speech to conference where the now Labour government, then in opposition, had announced this idea of day one unfair dismissal rights, and there was this sort of immediate recoil, I think, amongst a lot of employers saying, well, how's that all going to work? Unfair dismissal claims, even bad ones, are expensive to deal with. Tribunals are already up to its ears, masses of delay. Are you sure? Essentially, it seemed to be the noise. And then only a few days later, there was a speech by the now Deputy Prime Minister, Angela Rayner, in which she said, oh, don't worry, there'll be a probationary period, so it'll all be fine. And I think a lot of us, so I represent employers and only employers, I think it's fair to say, a lot of us were hoping that that would maintain some degree of status quo. So for some sort of probationary period, there'd be the same flexibility there is today during the first 2 years of employment, where as long as you're not discriminating, as long as you're not dismissing for one of those automatic and unfair reasons, you can dismiss for pretty much any reason you like. You could dismiss someone for the colour of their socks if you wanted to. Of course you won't, but that's really beneficial to employers, I think, because it avoids having to get into those sometimes quite adversarial conversations with employees about why their performance isn't up to standard, or why it's just not acceptable for them not to show up to work, and things like that. You can at the moment during a probationary period do things a little bit more gently, I think, and sort of explain to people it's not working out, or maybe things have changed, and therefore it's time to part ways. The way certainly my reading of the draft bill, the way that it will work is it will be an absolute day one right, with a limited caveat if you fall into certain categories during the probationary period. So it seems to be that the government's proposing a kind of statutory probation period, a period which either will apply by default or possibly which you'll be able to opt into, probably 9 months, they've said, although that's subject to consultation. And the idea is that during that period, the employer still needs one of the fair reasons for dismissal from the existing list in the Employment Rights Act. But if it has one of a shorter subset of those reasons, so as you say, it excludes redundancy, and interestingly, SOSR is in there, but it has to be SOSR relating to that employee, which is a slightly different test from the general one. If you fall within one of those categories, then potentially you can dismiss via what the government says is going to be a lighter touch process, without there being a valid unfair dismissal claim. Now, and they've also said that there may well be a lower threshold for compensation in respect to that period. Now, that obviously gives rise to a few questions, most significant of which is, well, what if the employee doesn't agree that you've got one of those reasons? Or what if the employee doesn't agree you followed this lighter touch fair process? And that, fundamentally is the challenge with unfair dismissal, isn't it? It's the word unfair. You and I and the next person might all have a very clear view of what we think is fair, but they may not all be the same. When you start to import those issues of fairness, and also this idea of kind of lighter touch process. We've got years and years and years of case law on what a fair process is for each of the grounds of dismissal. Introduce a new concept of lighter touch, you're going to have to be pretty specific about what that means, or else you end up with more disputes, don't you?
That's right, and I think they said something about the starting point as a meeting with the employee to explain the concerns, and they would be able to be accompanied by their trade union rep or a work colleague. But I'm kind of thinking it's got to be a little bit more than just a meeting. Maybe I'm wrong, but we'll see. Detail to be details to follow.
Sort of as an employment lawyer, it kind of feels like details to follow and then litigation to follow that. Because as with everything, if you leave a degree of uncertainty, then you have to work it out via litigation. And if you say lighter touch process, then there's got to be a meeting. It sort of feels like I don't know how many attendees are old enough to remember this, but I'm old enough to remember the old 3-step process where it was very rigid. And if you didn't follow those steps perfectly, then you were straight into unfair dismissal. I wonder whether. And I wonder whether, if you say there's got to be a meeting at which the person's entitled to be accompanied to talk about their poor performance, well, that can't just be a one and done meeting, can it? That can't just be, and therefore we are dismissing you. It sort of feels like they're anticipating it would be a meeting before a decision is made to give somebody a sort of last chance. But even that comes with some challenges. And does that mean you've got to, I don't know, start documenting poor performance from day one of employment in the way that you might if you were doing a formal PIP? It does feel like it's going to be somewhat more burdensome.
Yes. So we don't, obviously, so we don't know the details, but I suppose in terms of what employers might start to do now is, and I remember this from my time in practice, that employers had probation periods in their contracts, but they didn't necessarily take a great deal of notice of them. And you'd say, well, what happened at the end of the probationary period, and these sort of slightly embarrassed looks because actually there hadn't been a sort of end of probationary period meeting or kind of confirmation that you passed. So I think employers will need to make sure that they're very, they're good on their processes. And so you can start to get those things in place if you haven't already. I was just trying to think of something else that I suppose in terms of your recruitment decisions, people may be a little bit more careful about who they recruit.
Yeah. I mean, I don't know.
Basics.
I don't, if you've recently been interviewed for a job and had to go through umpteen levels of interview already, is it going to make that worse? I don't know, maybe.
No,
it also feels like you might have to train managers. Managers are used to the regime we've had for, a very, very, very long time, certainly for my entire career, where there has always been a period where it is easier to dismiss someone. And so managers would often have that point in time in mind. Well, we'll give them a little bit longer, but we know where we need to cut it so that we don't tip over into a potential unfair dismissal claim, even if it's a poor one. Managers are going to need a bit of explaining that isn't the way it works anymore. And so if you do spot poor performance or tardiness or failure to turn up or all of those things that might happen if somebody doesn't quite work out, you should be identifying them and documenting them from day one. When this comes into effect, of course, which is almost 2 years away at least.
Yeah. Good. Okay. So we'll move on to 0 hours and the right to guaranteed hours contracts. We've got structure, quite a lengthy structure here. I think it's about 15 pages, the way that I was looking at it on screen. It was, so the Labour, going back to what the pledge was to ban exploitative 0 hours contracts. And this is the mechanism that we've got. So again, there's quite a lot left to regulations, but the idea we think is that, workers will have a right to a contract that reflects the numbers of hours that they regularly work based on, we think, a 12-week reference period. And so workers who will qualify for this right are 0 hours workers or those who work a minimum number, a low number of set hours, and that minimum number of hours is left to regulations to be determined. So it's a little bit up in the air, isn't it?
Yeah, it is. So the government has said, so in its Making Work Pay paper that was published at the same time as the bill, they say we are banning 0 hours contracts, and they've not done that. It's not what the bill does at all.
No.
What it does is it, as you say, it entitles workers to the offer of a contract after a reference period that reflects broadly the hours they did and the times when they did those hours during the reference period. Reference period, technically TBD, but the government said potentially 12 weeks. And one of the really frustrating things for me is I don't know who it is who should be responding to consultation on this, because, as you said, they've talked about 0 hours contracts, and they've also talked about people who are on lower hours contracts. Making Work Pay paper says, well, it's not going to be full-timers, and it's not going to be full-timers to do overtime, but it could be anybody working slightly less than full-time. They're going to have to set, realistically, an arbitrary threshold somewhere. People whose hours are not guaranteed at a minimum of 2 or 5 or 10 or 20. And so employers out there will be wondering, does this apply to me? Is this something I need to be concerned about? And the answer is, don't know. No. and it is challenging, particularly because the way that it's framed is it's an offer to have a contract under which the employer offers you the hours. It's still not necessarily an obligation on the employee to do the hours. So it's sort of, if you have two-sided flexibility during that initial reference period where the employer can offer work but you don't have to do it, and the employer doesn't have to offer the work, it sort of feels from the initial draft like part of that flexibility is taken away because the employer has to offer the work, but there's no clarity that the employee has to take it up. You could, in principle, you could sort of build that into the contract, I guess, but one of the other provisions of the draft bill is that the terms have to be overall no less favourable, essentially, than the terms that were in place during the reference period. So query whether that will effectively preclude you from putting in place an obligation on the employee to do the work.
Yeah. And there's we'll see how tightly drawn the legislation is, but it would seem that there might be ways in which an employer, a slightly less scrupulous employer, might find ways around to, set the threshold just above what the minimum number of hours is, or we don't know. But I suppose also, given how complex the legislation itself is, let alone the regulations that we will need as well, I think it seems that the guidance is going to have to be really good because if workers are going to try and enforce this or make sense of it by themselves, it's going to need to simplify something that's actually very complex in the way it's been written.
Yes. Employers too. I mean, I think both sides are going to need certainty. This is, as you say, it's enforceable by tribunal action. Again, back to my previous point, it's not like the tribunals don't have enough to do and enough of a backlog, but this potentially might add to it. It's intended to provide rights to arguably some of the most vulnerable in society. The government says there are 1 million people on 0 hours contracts and who struggle to get mortgages and struggle to know if they're going to be able to pay their bills, and I think everybody has great sympathy for people in that situation. The challenge is, of course, making a framework that's simple enough to apply that both employer and employee or worker can apply it simply and know what their rights are, and also make it applicable to every one of an infinite number of potential working patterns. And I think one of the biggest challenges is the idea that it's not just offering the number of hours you offered during the reference period, it's the same times at which the employee was working. So does that mean if under the old contract I could ask you to work any time between 8 a.m. and 8 p.m, then the same terms apply? Or does it mean because you happen just to work the afternoon shift, I can only offer you the afternoon shifts, for example? And that's just one of a multitude of questions that employers may have about these provisions.
Okay. Interesting.
There is, incidentally, already a consultation out on this, sort of, because the bill talks about workers being offered these contracts. There is a consultation paper out because the government said in the paper that was published alongside the bill, we also intend to apply this to agency workers, and the idea there is that they won't going to allow employers to sort of circumvent the rules by contracting people out to agencies, and that's quite interesting because who do you enforce against? Because ultimately the agency is sort of sitting in the middle, whereas the end user is the one directing the individual's work and potentially setting their hours and the terms, so the fundamental terms. So it'll be interesting to see how that works. That consultation recently closed, but it's nonetheless something that I suspect will be fed into the next consultation about the broader question of how the guaranteed hours contracts will work. So if anybody's missed the boat on that one, they'll have an opportunity again to contribute to the next consultation, I suspect. Right, so we've had a question in, but should we leave those? I was going to leave questions to the end. Sure. It's a good one.
It's a good one. We'll come back to that. Good question. Right. Okay, so changes relating to harassment. Very close to my heart because I've just spent quite a lot of time on our various harassment-related materials. We've got here two two changes on the face of it. You know, there's an addition of a word here, and there's what looks like a small change there, but potentially quite significant, I'd say. So the first is that in the sexual harassment duty to prevent, we've got the insertion, or you could say reinsertion, of the word all. So the employer will have to take all reasonable steps to prevent sexual harassment. So this was in the original draft bill, and it was taken out. So the current position is the employer only has to the employer has to take reasonable steps. I'm trying to work out whether this is going to make a big difference. It's difficult to say because we haven't got any case law on how the tribunal is going to apply the current standard.
It's interesting, isn't it? I don't know. Do you think us lawyers get a bit too excited about one word, one 3-letter word, or because if I'm any lawyer who ever has to negotiate terms in a commercial agreement or a corporate deal, something like that, will tell you never agree to best endeavours, because best endeavours means, without regard to cost.
No stone unturned or something.
Well, no stone unturned, exactly. Yeah. You might agree to reasonable endeavours, and then there's always been this debate over, well, if you agree to reasonable, could you agree to all reasonable endeavours? Because all reasonable endeavours might be materially higher standard. In fact, it might be close to best endeavours. And so it sort of feels like, well, if it's not reasonable steps, it's all reasonable steps. Well, that must connote a materially higher standard. And if you've read the EHRC guidance on the existing, very recently implemented duty to prevent sexual harassment, the examples it gives are already applying a pretty high standard. I mean, there's an example of a theatre company that can't afford to do training, but whenever you book a ticket, you get a little note saying, "Don't harass our staff." I'm paraphrasing, of course, but that that seems to be a material change. The more extreme example is there's a construction company where there's a lot of inappropriate language being used, and it's very male dominated, and they write to every one of their customers and potentially go door to door to essentially warn them not to harass, not to sexually harass staff. So that's a materially more significant step, even on the current standard, than most employers will typically take. So query how much higher can it get by the implementation of the word all, but it does feel like it has to be something additional.
Something additional, yeah. And I think if it came to tribunal and maybe an employer had taken steps A and B, reasonable steps, but they hadn't taken reasonable step C, which perhaps is the step that would have avoided the sexual harassment having taken place, the tribunal might take the view, well, we don't know, but they might take the view, we haven't taken reasonable steps because you didn't take that one, even though you took those
because the harassment occurred. So how can you have taken all reasonable steps if the harassment has occurred? It almost feels like there's only going to be a very, very narrow set of circumstances where you could be successfully sued for harassment conducted, caused by an individual in your business, for example, and still be able to argue that you took all reasonable steps and therefore you're not vicariously liable. So it does feel like it's setting the bar really very, very high indeed. And that may well be a policy decision. It'd be very interesting to see ultimately what the HRC makes of it.
Yes.
Yeah.
What effect it has on their guidance, whether they make even
better. It's a bit like the third party bit, isn't it? I mean, so the existing guidance talks about harassment by third parties, even though technically the employer is not responsible for harassment by third parties. Of course, that's changing too under the bill.
Yes, indeed. So the second part is about protection from third party harassment, and this is interesting, isn't it? That it's sexual harassment, but also standard harassment. So
yes,
all. So it does put quite an onus on particularly hospitality, retail. Those are the obvious ones. particular risky areas where construction, perhaps where you've got people going on site, and given that harassment is about the not just the intent but the effect on the individual, it could lead to quite a lot of potential claims.
Yeah, potentially. I think that's right. Under the existing standard, the HRC guidance is clear you should be conducting risk assessments, putting in place steps to prevent third-party harassment, even though you're technically not responsible for third-party harassment, because the EHRC can take that into account in determining effectively whether you've breached your duty, and a tribunal can take it into account in a separate sexual harassment claim. So yeah, the expansion to other types of harassment, and also in particular the expansion to really give teeth to this idea of employers taking all reasonable steps to prevent third-party harassment is potentially quite significant. So anybody where you've got an external-facing role, particularly customer service, I think will be fascinating. I don't know quite what that means you will need to do, bearing in mind that you're responsible for that third-party harassment if you fail to take all reasonable steps to prevent it, even if it is a one-off. So I think we're likely to see a great deal of focus through those risk assessments on exactly what are you doing to protect employees who are at work, who are dealing one-to-one with customers, and particularly things like lone working policies, quite intensive training potentially for managers to know when to step in, some way of signaling to managers that you want somebody to step in. Some I think we're likely to see some quite significant steps, potentially changes in changes in terms of customer signage, potentially warnings to customers that they could be banned from the premises, they could be banned from all of the stores in the chain if they're considered to have committed unlawful harassment. So those are I think the potential step changes we might see as and when this comes on stream.
Yeah. Okay, so we are around halfway through. We're on to enforcement of labour market legislation. So this relates to Labour's commitment to amalgamating the HMRC, National Minimum Wage Unit, Employment Agency Standards Inspectorate, Gangmasters Labour Abuse Authority into a single enforcement body, the Fair Work Agency. So it will also deal with statutory sick pay. It will deal with Employment Tribunal financial penalty scheme. I've mentioned national minimum wage, working time, Gangmasters, modern slavery, and so there's some quite strong powers attached to it in terms of entering with a warrant in relation to Gangmasters. I think that is power to obtain documents and information, requesting LME, labour market enforcement undertakings. It feels like we've got these bodies that do these things, and we're giving it to one body. It's a question whether that body is actually going to have the resources it needs to perform all these different roles, I suppose. And it does what it focuses on.
It's going to be interesting, isn't it, to see how they spend whatever money is allocated to them. So this interestingly was a Theresa May policy as a single enforcement body, and the idea was, I think, which of course never happened under Theresa May's government, sort of pushed into the long grass a little bit. So what I think is very interesting about this is I think the intention is to try to enforce those rights which are not very widely enforced in the employment tribunals for a host of reasons, but particularly because they often tend to be kind of relatively low value claims and relatively complex claims. So minimum wage is a good example. It's already enforced by HMRC's minimum wage inspector, essentially, and they go door to door, checking up on employee compliance with minimum wage. Now, what the government has said about the new Fair Work Agency, which centralises that amongst a bunch of other enforcement activities is that it will focus only on the kind of deliberate wrongdoers. It'll be there to assist employers to do right, and it will really only go after the deliberate wrongdoers. That's not, candidly, my experience of HMRC's minimum wage enforcement, where sometimes it feels like it is somewhat motivated by a desire to identify sort of big names who might be might have inadvertently breached the regulations. And I think anybody who's familiar with it will know that the national minimum wage regulations are incredibly complex. It's one of those areas of law that should be simple, but is the opposite. And it's very, very, very easy to make a mistake that very technically puts you in breach of the regulations, even though nobody's ever complained and nobody would ever think it was breached in the first place. And a fine example is a policy that says wear black trousers to work. Well, that potentially puts you in breach of minimum wage legislation if you don't deduct from your minimum wage calculations the cost of a pair of black trousers once in a while. And there are some good examples of companies that have fallen foul of that. So I think when it comes to enforcement by the Fair Work Agency, my particular area of interest will be holiday pay, because that's something that's not centrally enforced at the moment. And it is, again, an area of the law which should be very, very straightforward and is anything but. It's mind-bogglingly complex. Yeah, it's one of those areas where, you know, if you've got somebody who works precisely the same number of hours every week and gets paid precisely the same amount every week, easy. But any other situation where you've got any other degree of variability in pay, it gets very complex indeed. And that complexity has been somewhat compounded by the introduction of new legislation this year, which has, for the first time, introduced a potential argument over whether annual bonuses or other variable pay, which is unaffected by you taking holiday, might have to be included in some types of holiday pay for some days of holiday or for some proportions of some days of holiday. Now, the challenge with all of this is there's no easy way of working any of this stuff out. I'm delighted to say I know quite a lot about holiday pay, but I also know that there are some questions to which there are no answers yet. So it'll be interesting to see what the Fair Work Agency does about those areas of the law. You would hope that it wouldn't seek to enforce in areas where there is a lack of clarity, but I wonder if what they might do is put out some guidance on what they think the answer is. And then smaller employers who want to avoid any enforcement action will simply comply with what the Fair Work Agency says they think the answer is in terms of how you calculate holiday. And larger employers who might think the Fair Work Agency has got it wrong because the law isn't certain yet in some areas might then challenge the Fair Work Agency's determination and take on that fight. And again, this all comes back to, well, where do you want to spend your money on the Fair Work Agency? Do you really, really want to go after the deliberate wrongdoers, who might be the small ones sometimes, where the cost of pursuing them might massively outweigh the recovery? Or do you want to go after the big names knowing that they're not going to fight unless, but they might fight if they think that there is a point of law that is unclear, and then again enormous cost in fighting those potential enforcement activities.
And you and I, we've looked at the guidance that the government itself has brought out on the holiday pay changes, and there are lots of questions that haven't been answered. So it would be nice if they did get answered at some point.
It would, and I think a lot of us are expecting there'll be case law. So that bonus point is a really interesting one. Another one is expenses. The new legislation doesn't carve out expenses from the categories, or doesn't, on the face of it, very explicitly carve out expenses from the categories of payments that don't have to be included in the 4 weeks of holiday guaranteed by EU law. And actually, I think it can be read in a way that does carve out those payments, and I think it would be slightly ludicrous if you got, a chunk of money in your holiday pay to represent your mileage because you happen to be driving a lot in the few weeks prior. But nonetheless, that needs to be kind of clarified by the courts ultimately. And so it's going to be interesting to see how things like that are enforced, or what kind of guidance is given on issues like that when employers and employees might take different views on what the law actually is.
Right. Gosh. Okay. So we're on to fire and rehire. So at the moment we have the code, which is not particularly forceful, I'd say. What we have here is a proposal to introduce a new automatic unfair dismissal if the reason for the dismissal is that the employer seeks to vary the contract and the employee doesn't agree, or the dismissal is to enable the employer to employ somebody else or to re-engage an employee under a varied contract to carry out substantially the same duties. So, eliminating fire and rehire or not. There's also an exception on this. So it's a very narrowly drawn exception where it's necessary for the employer to eliminate, prevent, or significantly reduce financial difficulties affecting the business. And I think this is the tricky one as well, is that the employer could not reasonably have avoided the need for the variation. I think that's going to be really difficult to establish, even if you're a company in financial difficulties.
Yeah, it sort of feels like that's an exception that might not even apply if the employer's insolvent. So, you know, you have to you're varying so as to mitigate or eliminate or reduce financial difficulties which affected your ability to carry on as a going concern. Okay, well, you know, insolvency or being on the cusp of insolvency would satisfy that. But you, in all the circumstances, you couldn't reasonably have avoided the need to make the variation. Well, there's always alternatives. You know, in any commercial organisation, you make decisions about where to spend your money or where to cut your losses, and employee costs are one of them, but not the only one. So it'll be really interesting again to see how employment tribunals interpret that. I would hope sensibly. I would hope the word reasonably will do a lot of the heavy lifting there, and will enable employers to take give employers a bit of latitude. I'd also hope that there are some changes at consultation stage, because I think this is much wider than it's intended to be. I think what the wrong that this is intended to address is the situation where an employer effectively forces swinging changes to terms and conditions on a large group of the workforce as a means of reducing cost without a sufficiently strong justification. Now, there is actually technically some law that stops the employer from doing that now. It's called unfair dismissal. And it is not as easy as it's sometimes made out in the press to be for employers to go through that process, although it is doable in the right circumstances. One of the big problems, I think, with the way this is drafted as it currently stands is it applies to situations that I don't think it's intended to. So, for example, let's say you're an employee and you've got 3 employees who all do tasks A, B, and C. Every one of them does all 3 tasks. And you decide for efficiency purposes that you'd actually much rather have one employee doing task A, one employee doing task B, and one employee doing task C. Yeah. Well, maybe their contracts don't permit that, because their contracts say specifically they do A, B, C, so you can't force it on them. And it's not really a redundancy, you'd argue. Well, you might argue it's a redundancy. You might say that the need for the ABC work is reducing, but really, actually, the need for the A work, the B work, and the C work is the same. It's just that the way in which you're arranging it is changing. So maybe it's not a redundancy either, so it doesn't fall outside the fire and rehire provisions for that reason. So it kind of feels like when you approach the employees and you consult with them, you say, look, we want to retain all of you. This is not to get rid of you. This is not to reduce your pay. We're not trying to make things worse for you. But you say to them, we're going to consult with you about changing from A, B, and C to just A or just B or just C. And then you offer them a new contract. It feels like you're squarely within these provisions, and so squarely into automatic unfair dismissal potentially. Again, I just don't think that's the intention. I think it would massively restrict employers trying to make sensible commercial decisions. And again, I think it's hopefully something that will be flushed out in consultation, particularly given some of the sanctions they're thinking of. Interim relief is what's proposed for this. Employees potentially, or trade unions, trotting off to tribunal and saying, we want you to effectively issue an order, kind of an injunction, that prevents the employer from making these changes because we think they're in these provisions. And that's a very, very big change in terms of enforcement of employment rights. There's only very narrow circumstances in which you can do that at present.
So I suppose for employers now, are people starting to look at variation rights in employment contracts, would you think?
I think that's sensible. So those provisions in employment contract that says we reserve the right to make changes to these terms, something along those lines, I think it's very sensible for employers to start looking at that, because then you can argue not varying the contract, you're just implementing one of its terms. Obviously, there are some restrictions on the circumstances in which and the degree to which you can rely on those provisions, but it at least gives you a starting point that doesn't squarely put you within these provisions.
Okay, well, we've covered our 5 topics, and if anybody else has questions, if you want to put those in the chat, shall we make a start with the first question? We've got the question from Tom Price. Does the right to reasonable notice of shifts apply to workers who are contracted to work a set number of hours per week with variable rest days? So we're talking here about the guaranteed hours provisions, the 0 hours changes, and one of the elements of that is the right to reasonable notice of shifts. Any thoughts on that?
It's a really interesting question. So I think first off, what do we know and what do we not know about these provisions? Well, what we do know is that these provisions are going to apply to 0 hours workers. That's somebody who's not guaranteed any work, basically. Well, at least we know that that's what the draft says, I should say. Even that in theory could change. I think it's unlikely to, but that in theory could change. So I think that's the starting point. The scenario that's been given is not a 0 hours contract, though. So what else do we know? Well, we know also that these provisions are going to apply, including the guaranteed hours contract offer, are going to apply to a situation where the employee or the worker has a contract that provides for a lower number of hours, but we don't know what that threshold is. So in theory, the right to a guaranteed hours contract, for example, could apply in the situation that this question deals with, where you have somebody who's on a part-time contract. Maybe the days that they have off each week change, maybe they don't, but they're below a certain threshold, and therefore these provisions apply by default in terms of the guaranteed hours contract. Okay. Then you get to the provisions on the right to reasonable notice of shifts and reasonable notice of cancellation of shifts. Now, reasonable notice of shifts says simply an employer has to give a worker reasonable notice of shift if they're on a 0 hours contract. Well, that's not this scenario. Or they're on a contract of a specified description that makes the work available but doesn't provide on what days and at what times, or in accordance with what pattern of days or times the work is to be done by the worker. Okay, so let's unpick that. If you're on a part-time contract where the days of the week that you have off vary, well, you might be on a contract of a specified description, but that's sort of, further clarification required. It requires the employer to make some work available to the worker. Well, that seems to be satisfied here. Let's say you're required to do 20 hours a week. It's just the days of the week you work differs. But it doesn't provide under the contract what days or at what times or in accordance with what pattern the work has to be done by the worker. Well, on the face of that, potentially, yes, it would apply to the person in this question, where the days of the week on which they take off change. It kind of depends on the terms of the contract, though, because I suppose you had a situation where you said, okay, in week 1, you get Saturdays and Sundays off, and in week 2, you get Mondays and Tuesdays off, and that just rotates. Well, then you would fall outside that because you very clearly set out what the pattern is of working days and non-working days. I think this is probably one area where we're going to have to wait and see what the final legislation says, and then employers are likely to start shaping, or employers in the scenario given by this question are likely to start shaping their contracts around precisely what the provisions are. One thing that occurred to me is whether the government might through the process of consultation rethink this and maybe think about a different or an additional threshold for the application of these rules. So, for example, they could say, well, it's not just people who work below a certain, or whose hours are guaranteed below a certain level, but it could be people whose hours are guaranteed below a certain level and who are paid less than X amount. The theory being people who are paid more than X amount might not need as much protection. But again, that's all kind of TBD, and that's just but I just made that up. There's nothing to suggest the government is thinking about doing that.
It's a nice idea, because it's about the balance of, the sort of relative bargaining power, isn't it, in a way, between employer and employee. And if you're on low wages and low hours, you've got very little power in saying what you want in the contract, whereas somebody who gets £1,000 a day or something is probably more likely to be able to turn down the work or find work elsewhere.
So that's what the rules will be when you and I rule the world. But sadly, until then, we're left without a great deal of certainty right now.
We never know. See where it shapes up. And we have another question. Can you clarify what employers should start to think about in relation to fire and rehire? So we mentioned about variation clauses, so including in your employment contract, and I mean these are fairly standard to include something like this. I think we definitely have them in our senior employment contract. From memory, I'm not sure we do in the standard employment contract. And I suppose it would need to be fairly tightly drafted, but you want to be able to say we have the right to vary the terms of the contract, and normally you should put in something about reasonableness, wouldn't you, or something like that. So
potentially. You probably also got to think about, so you'd think about the language that you were going to use. If you've not got one of those clauses that allows for the employer to sort of unilaterally vary, you'd certainly think about implementing one or taking a look at your existing drafting. Does it do what we want it to do? But then there's the other bit of it, which is arguably the harder bit, which is how do you put it in place? Because it's all very well for a new hire. You just stick it in your template. But if you're going to make changes, it's not just going to be to the new hires. So how are you going to implement that for your wider workforce? So I would suggest, if employers are thinking about implementing those clauses, don't just put it in your template for new hires. Think about, well, is there an opportunity coming up at some point to do an update to terms and conditions? Employers need to do that from time to time. Maybe there are other provisions that need updating, post-termination restraints, for example, something like that. Maybe we want to harmonise notice periods or whatever. But you're going to need to do that at a point where you've got sufficient leverage, sufficient incentive for employees to sign up because they don't have to. And sufficient consideration that it's enforceable. So, maybe next time you're thinking about doing pay rises, maybe the pay rise is going to be conditional on signing up to the latest and greatest terms and conditions, of which that might be one, and doing that ahead of the implementation of the bill. The other obvious thing, of course, for employers to think about is if you're thinking of making material changes on a kind of, I hate using the word fire and rehire because it's applied in circumstances when it's not really what that means. But if you're thinking about making structural changes to your workforce in circumstances where these rules might apply, well, you might be well advised to do it now and not wait a couple of years when these new rules will be in place, or 18 months.
And just making sure you comply with the code of practice. Another question, just thinking, working time regulations make provision to disapply rules in certain circumstances, and whether something like that could apply with this. So I've read that question without.
I think this is a follow-up to the question about whether the obligation to give reasonable notice of shifts applies to workers who have a sort of set number of hours a week, but where their rest days vary. So we obviously we answered that one earlier, and so the question is whether there'd be something a bit like the working time regs where you could disapply. So the answer is there could be, and if that's something that you as an employer or employers out there think would be sensible. I think then now is the opportunity to raise that via or very shortly when consultation goes ahead on this stuff. That will be the time at which to raise that as an option and explaining why that is sensible and in the interests of both employers and employees. I think there's a couple of hurdles to surmount, or there's a hurdle to surmount, and also potentially a positive in what's being suggested. So the hurdle is the general view that contracting out of employment rights is not the done thing, because employers might use their greater bargaining power to force employees, particularly vulnerable employees, to sign up to terms which waive their rights. That would be the argument that is run. The counter argument could be, for example, what we need really is a wider workforce agreement. So maybe where there is a trade union in place, or maybe even given the government's desire to introduce sectoral collective bargaining in some sectors, maybe that would be the scenario in which actually it would be possible to depart from these provisions on guaranteed hours, or on notice of shifts, or right to reasonable notice of curtailment or cancellation of shifts. I think that might be an area where maybe there's more latitude, because the sense is that there is greater balance of bargaining power. But I'm not a politician, so it's all for somebody else to think about when it comes to the consultation process.
Thanks, Stephen. So we have another question. What are your tips in ensuring that sexual harassment risk assessment is comprehensive enough? I've just written a precedent on this, so I should have a view. I think it's obviously going to vary depending on what your sector is. But I think what you're doing is looking at the risk areas. We talked about earlier about lone work. Are there lone workers? Do employees workers have contact with third parties? Are you customer or client facing? And these are all factors that the EHRC, the Equality and Human Rights Commission guidance talks about. Alcohol. Is alcohol involved in the, so obviously it is if you're working in a bar or restaurant. Have you got an imbalance of power in the workplace? So this is particularly, obviously all workplaces have more junior and more senior members of staff, but that is a risk area where you've got people who control the work, the projects, pay, bonuses, that kind of thing. So allocation of work, that kind of thing. So are more junior members of staff more at risk? Think about whether you've got people who've got less certain work, so 0 hours contracts, that kind of thing as well. So those are the kind of risk factors. And then it's a question, I think, of devising the questions that enable you to kind of pinpoint where your risks are. So do we have these kinds of workers? Do we have issues? Have we had complaints? Looking back at whether you've got complaints for the last 2 years involving harassment, sexual harassment. Also looking at things like staff surveys, particularly anonymous staff surveys. Do you have mechanisms for people to complain without having to go through their manager or an alternative manager? So identifying the risks. The HRC guidance I've found is quite helpful on this. It's not specific. It does give, so Stephen gave the examples before. It talks about the construction firm. It talks about someone in a theatre company, and there are a couple of other examples. And it gives you some kind of guidance. It's not a template to follow, but it will make you think about the risk areas in your workplace, or the workplace that you're looking at, and come up with questions, and from that devise the steps you think will help mitigate those risks. So it's a bit of a long-winded answer, but
I think it's a perfect answer, Cathy. I agree completely with all of it. I was just going to add that the other part of it I'm really emphasising to our clients is the importance of review. So it's not a one and done process this risk assessment. It's having someone who is responsible, who is identified as being responsible for reviewing the efficacy of internal policies and whether the risk assessment still, holds water, and where necessary, updating it. I mean, ideally annually, I would say. So then you have your risk assessment, and then let's say something happens, there's an unfortunate incident. Well, then you can update the risk assessment if you feel that it was deficient in failing to identify that particular risk scenario. We're all familiar with the alcohol at the Christmas party and the work trips with lone workers or with two people on a work trip together. But and we're familiar from the HSC guides with a whole bunch of others. But I'm sure that most employers will come across scenarios that they didn't anticipate as they go along, and that's why that process of review is so very important.
Yeah, agreed. So as well as we have also produced a checklist for anyone looking at a risk assessment and an action plan with a monitoring log, which draws on the EHRC action plan monitoring log that they, I think, originally devised with UK Hospitality. So theirs is very much hospitality based, but we try to broaden it a little bit more. I hope that answers your question. Just going to scroll down and see if we've got a couple more. So there's a comment about steps being taken to try and reduce the risk of harassment, and the question is to put up signs saying, please don't harass people because of protected characteristics or on the basis of sexual harassment. Feels very backward, but it seems necessary to be able to prove reasonable adjustments are being made. I think that's true. It's funny because I think I was on a call recently with my internet service provider, and I was reminded to treat them with respect and that kind of thing. So I think people understand why these signs are going up in workplaces, in restaurants, in shops, etc. And it's there for I think it's there for a reason. It shouldn't necessarily be an automatic step to put up a sign, but it's one of the more obvious steps that EHRC has suggested. So to not put it back, to not put one up, would feel like you're running counter and maybe not doing yourself any favours. It's a fairly straightforward query.
Yeah, query whether it's more socially acceptable. And it's only one step, of course. There's a whole load of other things you should be thinking of too. But query whether it's actually relatively socially acceptable already to do it. You see signs, don't you, on public transport saying, please don't harass our staff, please don't verbally abuse our staff. Well, it's essentially doing no more than that in different settings. So you'd hope that would be something most employers, at least with public-facing workplaces, would be able to put in place relatively easily without too much consternation.
And we have, I think, we're running out of time, but maybe time for this quick question quickly. What if the company isn't taking harassment seriously? Where should an employee flag behaviour to? I suppose it's HR is the obvious one, isn't it? I mean, if the company is not taking issues of harassment seriously, in terms of flagging the risk, not of a specific incident perhaps, but if you just want to say you really need to be looking at this a bit more closely, you might want to flag it to a manager. But if it's
I wonder if this might be an area where the questioner might want to seek their own personal legal advice. But it's most employers will have not just the sort of classic route of HR, but they will often have some sort of whistleblowing hotline or similar. there will often be in a policy, in the grievance policy, something that says, if you're raising issues relating to your direct manager, you should raise it to this alternative route, so that you don't have somebody dealing with a complaint about themselves. There's all manner of different mechanisms depending on size and scale of employer. I wonder if this question is driven from a particular viewpoint, which might necessitate a bit of personal advice.
Your suggestion is a good one, Stephen. We are out of time, so I just want to say thank you very much to Stephen. Thank you to all, especially those who've submitted questions, and I hope you found it useful and enjoyed it as I have. So thank you very much.
Thank you all.
Bye.